Presentation is about the plight of the Haggala and the future of biodiversity conservation. Haggala is the first legally designated strict nature reserve under the Fauna and Flora Protection Ordinance. It is situated in the Central Highlands Forest Complex in Sri Lanka and covers an area of 1,142 hectares. A strict nature reserve is a protected area in which the fauna and flora are preserved in their pure natural state due to its rich biodiversity and high endemism. Haggala serves as a water tower supplying water to the Uva Basin in Badola district. The water from Haggala is drained into Umaoya, which feeds the Rantabe Reservoir and the Mahavali scheme system B, C and E. In addition, its hydrological importance as a mountain cloud forest in contributing to downstream water quality, precipitation, fog disposition and microclimate stabilization is immeasurable. Encroachment constitutes by far the largest threat to Haggala, and the encroachers include mainly Ambevela Cattle Farm, Warwick Tea Estate and other small-scale cultivators. Currently, more than 38% of Haggala is encroached upon and the majority is accounted by Ambevela. About 1,200 people in 200 households are estimated to be living inside Haggala, covering approximately 50 hectares. Consequently, Haggala is plagued with severe soil erosion because of clearing the land for cultivation and planting tea with a slope of 45 to 50-degree angle. The rate of pollution is accelerating due to increase in human activity, dumping garbage, and heavy application of agrochemicals. In addition, encroachers extract water for irrigation by inserting pipes into the natural springs. Clearing forest land leaves Haggala vulnerable to the threat of invasion by alien species. Haggala is an ongoing legal case. In 1988, the EFL first filed a case against illegal encroachment into Haggala. However, the rule of law was undermined by the authorities, bringing the prevailing political uncertainty and security concerns in Sri Lanka as an excuse. Again in 2006, a landmark national case citing DWC, divisional secretariats and other government institutions was filed. This case was successful as the respondents agreed to halt encroachments and evict the squatters. However, in 2012, EFL reopened this matter due to non-compliance with the settlement terms. Ambevela Farm and a group of encroachers with permits were allowed to enter the case as respondents. Currently, objections and counter-objections are due. Here are some of the achievements made so far in this prolonged battle. CEB has stopped granting electricity to illegal residents without written documents. Relevant divisional secretariats stopped issuing further grants and permits. In 2019, DWC has taken satisfactory steps in surveying and demarcating Haggala boundaries. Legal actions against new encroachers are carried out. A range officer is positioned. However, the degradation continues. Due to political pressure, it has been difficult to remove illegal settlements, although Wildlife Department has got eviction orders. The major issue resides with Ambevela Cattle Farm, which is leased out by the government for 50 years in 2001. A court order is required for the government to revoke its own lease. This brings our attention to how in the first place the government alienated this public property strictly protected by law. Under the State Land Ordinance, it is prohibited to grant, lease or dispose of state lands above 5,000 feet in elevation, which includes the entire area of Haggala. Accordingly, it is clear that scant regard was paid by the state to public trust doctrine, intergenerational equity and sustainable development. The government would rather ensure that people had adequate access to good nutrition than restoring ecological balance. Irresponsibility of the Wildlife Department, which is the statutory body mandated to manage the area on behalf of the citizens, is also to be blamed. Haggala is an underfunded and poorly protected natural reserve. It has been deliberately excluded from several major conservation initiatives, such as the most recent, the ADB-funded Protected Area Management and Wildlife Conservation Project. Examining the existing domestic, international and regional legal framework regarding forest conservation in Sri Lanka is critical when addressing this issue. Sri Lanka's protected area network is regulated and managed mainly through the Fauna and Flora Protection Ordinance, Forest Ordinance and National Heritage Wilderness Areas Act. They enable the government to designate certain areas as protected areas and prohibit many activities such as encroachment, illegal extraction of natural resources, clearing for agriculture, forest fires, development projects, and poaching. The National Environment Act specifically imposes a duty on the Central Environment Authority to identify and protect critical watershed areas. In addition, there is a wide range of related environment policies and action plans such as Forestry Sector Master Plan, National Forestry Policy, National Biosafety Policy, and Biodiversity Conservation in Sri Lanka. Furthermore, Sri Lanka is a party to the International Plant Protection Convention, Convention on Biological Diversity, International Tropical Timber Agreement, UN Convention to Combat Desertification, and Cartagena Protocol on Biosafety to the Convention on Biological Diversity. There is also a growing realization of the necessity for regional cooperation on environmental issues, which led to the founding of the South Asia Environmental Cooperation Program and SAARC Forestry Center. Moving on to some great lessons from other South Asian countries. Bhutan is the world's only carbon negative country and has the greatest rate of forest cover in South Asia at 80%. Rigid environmental policies, constitutionally guaranteeing that 60% of the country is forested, have aided the country's forestry efforts. These measures are part of the country's 4 pillars of gross national happiness. The Bhutan Trust Fund for Environmental Conservation, established in 1992, has seen the cumulative growth over 27 million euros in 2011. The fund generates interest to provide grants focusing on biodiversity conservation, and it has contributed to making 9 of the 10 protected areas operational. In 2011, India rose to the 8th place among the top 10 countries with largest yearly forest area gain. Both the national and state governments are jointly responsible for this sustainable management of the forest resources through establishing specialized institutions and engagement of local population. The active participation of the judiciary in environmental litigation by upholding emerging principles of sustainable development is well recognized in India. Greening the fundamental rights and guaranteeing that the right to live in a clean environment is an extension of right to life is a quantum leap in India. Despite being accorded the strictest protection by the state, Haggala has been progressively degraded over the past decades. Therefore, urgent and immediate action is crucial before the irrevocable damage is done. First, an eco-centric, resource-oriented long-term national policy is necessary. Then, appointing a specialized joint commission with top-level decision-making powers and comprising of non-government appointees from relevant sectors of academic research, industry, and social groups is ideal. A strategic action plan providing realistic targets such as the expected reforestation cover within set time periods and budgetary allocations should be introduced. Independent review of the progress of the Commission is critical to ensure the transparency, public accountability, and good environmental governance. Compensatory schemes based on the polluter pays principles for the offenders must be enforced. Then, a detailed inventory and a comprehensive study on the fauna and flora, socio-economic and cultural values of Haggala is important to educate our citizenry of its immense importance as a critical watershed. This brings us to the end of the presentation. Thank you.